Terming it a double whammy for the consumer and unfair trade practices, Delhi High Court upheld centre's move to ban mandatory levy of service charge by hotels and restaurants, ruling that such payment must be discretionary. Service charge or tip, as it is colloquially referred to, is a voluntary payment by the customer. It cannot be compulsory or mandatory. Practice undertaken by restaurant establishment of collecting service charge, that too on mandatory basis, is coercive manner, would be contrary to consumer interest and is violative of consumer rights. Justice Pratibha M. Singh observed in landmark pro-consumer ruling. Court said service charges being arbitrarily collected and coercively enforced while dismissing a batch of petitions filed by two restaurant associations challenging Central Consumer Protection Authority guidelines. It also slapped cost of rupees 1 lakh each on them payable to authority. CCPA has issued guidelines in July 2022 to prevent unfair trade practices and violation of consumer rights. Agreeing with CCPA's stand, High Court said collection of service charge and use of different terminologies for the said charge is misleading and deceptive in nature. Same constitutes unfair trade practice. It underlined restaurants by mandatorily collecting service charge are in fact misleading and consumer about the actual price of products on the menu card. In fact, when a large number of food items are ordered, most consumers may not even notice levying of service charge, that too in small print, and may end up paying much higher amount than what is chargeable. This constitutes unfair trade practices. High Court observed that manner of enforcement of payment of service charge is also coercive in nature, and it highlighted that often service charge is being confused with service tax or by mandatory tax imposed by government. In fact, for the consumer, collection of service charge was proving to be a double whammy. That is, they are forced to pay service tax and GST on service charge as well. This position cannot be ignored by court. It said camouflaged and coercive manner in which service charge is being collected by restaurant establishments itself shows that unlawful nature of the charge, and suggested CCPA considers allowing change of the term service charge, which is nothing but a tip or a gratuity or a voluntary contribution. Dealing with the merits of the matter, High Court emphasized that mandatory levy of service charge is against public interest and imposes additional financial burden on customers regardless of consumer satisfaction for the said service, brushing aside claims of Hotels and Restaurant Associations of India and National Restaurant of India in their 2022 petitions that levy of such charge is part of right to conduct their business. High Court countered that it has to balance the rights, as consumers also are entitled to know price that is being charged. Larger interest of consumer cannot be ignored or stifled in a manner contrary to law. Fundamental right to conduct business would permit restaurant establishments to charge for the food being sold as also service being provided. However, right to carry on business cannot result in exaction of amount which consumer neither bargained for nor agreed to pay. Court pointed out it is a problem experienced by most customers of not even noticing the display of collection of service charge which may be printed on menu card. It said that what invariably happens in most establishments is that after the food is charged, a service charge of 10 to 12% is added by default and taxes are charged over and above the said amount. In effect, therefore, consumer end up paying 10 to 12% more simply because addition of the service charge.